Clause 8 is part of IP Watchdog and sponsored by Harity, the go-to firm for the Patent 300 for patent preparation and prosecution. If you enjoy this podcast, please share it with others and leave a 5-star rating. And now here's your host, Eli Mazur.
Welcome to Clause 8, the new season of Clause 8. I know a lot of the people who listen have been asking me when we're coming back, and we're finally back with a great episode for you. I'm going to try something new this season, kind of try to make it less formal, more fun. My first guest and I are both from the New York City area, so kind of maybe revive some of that radio talk fun that we from a different era on this podcast. So hopefully I'll have more episodes out, and I'm lucky to be joined today by Bruce Berman, the PR guru himself of the IP world. He is the CEO of Brody Berman Associates, which is a communications firm that helps tell patent stories. And that's a theme that comes up a lot on my podcast, obviously, about who and when should they tell stories that kind of help promote their cause in the patent world. And he's also the founder of the Center for Intellectual Property Understanding, which kind of has a similar mission. And then finally, he's been involved in lots of interesting projects over the years, including helping to found IAM, wrote lots of interesting books, including Making Innovation Pay, about turning IP value into shareholders. And now he has his own podcast as well. So Bruce actually has a distinction of being the first fellow podcast host to be as a guest on the Clause 8 podcast. So welcome, Bruce.
It's good to be here, Eli. Thank you.
You're not an attorney. You're not an engineer. You actually were getting your PhD in film history at Columbia University, and then somehow you ended up spending the rest of your career promoting IP rights. How did that happen?
That's a good observation. I was always writing. From the age of 19, I wrote professionally for various magazines, newspapers, etc. And I like teaching and communications and film, which is copyright focused, tax shelters and things of that nature. I covered some of them, but then I started to evolve into writing on other topics, business topics, and I like that. So I went from frames to claims, so to speak. But it was, it's not as illogical today as I would have thought, because when you're dealing with the specificity of a photograph or a film frame, there's a lot of information, and there's a lot of information in a patent, as you know. What they both require is context, narrative, to kind of put a frame around them. And that's what I guess I do.
Do you remember when you first heard about a patent? When was like your first patent-related project that you worked on?
I was very aware of copyright in film, of course, but in 1989, we were doing investor relations. I had founded Brody Berman, and we were focused mainly on marketing Wall Street research. And at that time, my partner, Ira Brody at that time, he had a friend at Kenyon Kenyon. They had lost that huge case against Polaroid. It was $907 billion, $1 million, almost $1 billion, just under $1 billion. And at that time, that's like $2.2 billion today. That's a huge loss. And they paid it, so Kodak did. So Kenyon's reputation was tarnished, even though they kind of generated 10 or 20 million in fees, but but they lost the case, and people remember that. They mitigated damages. It could have been 12 billion, actually. But no one remembers that. So they contacted me through this associate, and they said, what can we do? What should we be doing? And they had the original business card from 1854, the same font. Hadn't changed anything,
I didn't realize business cards went back. So
I didn't either. But the font from the card was 1854. They hadn't changed a thing. They weren't into changing anything. But they knew they had to, and they knew they needed to kind of remind people they're still here. So they treated me, engineers like to deconstruct things. They deconstructed what I do, how I do, and I'm glad to share that and be transparent, because there is method to the madness of my career. And similarly, they wanted me to understand how they worked, and they treated me like an associate. And I didn't mind. I didn't have to take the LSATs, no bar exam. So because there was no testing, I remembered everything. I wasn't required to, but I did. So I liked it, enjoyed it, and it was kind of fascinating. And they are a good firm, or were. And only until about 2.5 years ago, they were still in business, Kenyon, one of the very few.
So your entryway into this career of telling patent stories was through a law firm. I think you've written about it as well, about patent attorneys being kind of risk averse to being out in the media. An instinct might have been in that situation to say, well, let's just write this out, wait till everybody forgets about this Polaroid versus Kodak lawsuit and our role in it. We'll try to do good work for our existing clients. They'll appreciate it. And we'll kind of build back to what we were without that. I mean, what do you think kind of made them think, well, maybe we should go out into the world and take the risk of telling our story?
That's a really good question. I think it was divided among the partnership. Not everyone wanted to be visible, and they thought they'd just sort of, stay where they were. They certainly were busy. They weren't like starving, but they knew that in order to be a future, this was 89, 90, I guess, 89, 90, and, CAFC, Court of Appeals, was established, and Bayh-Dole was active and in force. So they saw that opportunity there. Although at that time, Kenyon was almost exclusively defensive in orientation. Yeah. So they were handling the other side of the Robert Kern suit, the windshield wiper. They were representing the consortium of U.S. auto companies, Japanese auto companies. It was a big deal. So they were mainly defensive, which was interesting. And over the years, they evolved into being more of a plaintiff's firm, like many other firms.
So what do you think kind of prompted them to say, let's go out into the world?
I think they saw the potential damage, collateral damage from losing or appearing that they were the loser. That was one. I think they saw opportunity to be more visible. Some of the partners did. And how you did that was very important to them. They didn't want to just take an ad out in the Wall Street Journal and say, here we are, as some law firms have done over the years. But subtly, we just raised their profile. They became observers of other cases, litigation. They were able to comment. Generally, they didn't want to comment on their own cases. But then they also, I think they learned, as did Morgan and Finnegan, where I worked for 12 years. I worked with Kenyon for about 5 years, 4.5. And I worked with Morgan Finnegan for about 12 years. And they learned, particularly Morgan Finnegan, how to use me well. Whether you were representing a plaintiff or a defendant, you were going to have to deal with some level of media awareness. It was going to be written about the case. So you wanted to make sure it was accurate, that was your client was depicted accurately, or the case was. And I think that was their big motivation. Kenyon, a little less so at the beginning. They didn't really go there with me.
So that's interesting. It's kind of an evolution where Kenyon is happy to for people to be aware they're a big patent litigation firm. I guess that's the story they want to tell. But they weren't really ready to kind of be involved in telling the stories about their own litigations that were going on, or
correct.
Other ones. And it's this is a very common view as well that you hear about from, patent litigation attorneys, is that, nobody really actually pays attention to news coverage about patent litigation. What it can only do is come back to haunt you if you say something wrong or misspeak, or something's presented in a way. You should really kind of reserve all of your arguments and everything that you have to say
to the court.
To the court, yeah. What did make Morgan Finnegan decide? No, there is value to telling that story outside of the legal briefings.
It's how you tell the story. It isn't necessarily the lawyers involved in the case who are telling the story. It may be a third party explaining or providing context for why is this case important? Why is the plaintiff in this case, have a strong position? and or the defendant. But that could be a third party. It doesn't have to be the lawyers. Typically, it isn't the lawyers involved, and they don't want to say anything because whatever they say can and will be held against them. But I also worked with a little digression, a lot of expert witnesses, many over the years, from Ocean Tomo to Ernst and Young, many, and that's an interesting corollary, sort of, to working with lawyers.
I've had a lot of guests. Josh Malone comes to mind, and he kind of said that he was who kind of said, the only way I will win my case, who's the inventor of a bunch of balloons, who, in many views, had a successful, I guess, patent litigation. I'm not sure he thinks that, but he said the only way I'll win my patent litigation, instead of it lasting for 10 years and them running me down to the ground, is to have a parallel PR strategy at the same time. Let's say, any litigation that you're involved in, a patent litigation, you're representing a patent owner, any kind of patent owner as independent inventor or NPE, you're going to be filing a lawsuit to enforce your patent. These days, you're going to be, let's say you file it in the Western District of Texas, as an example. And these days, that patent will probably be challenged at the PTAB. There's a likelihood that case is going to go up to appeal to the federal circuit. Ideally, your goal is to kind of, I don't know if this happens, is to shame the defendant into settling, right? That could be, and Bruce is shaking his head. No,
well,
is not.
I can be. I think it's much less mysterious than you think, than many people think. It's really telling the story or providing the background that's accurate. Because very often it isn't. If it's let's say an NPE, immediately it's a patent troll case. And that's not always fair.
But who do you want to tell that? I guess who do you want your audience?
Well,
to be
ideally,
for that story?
If you tell to the IP community, IP Watchdog, IAM, IP Law 360, that helps because the writers for the Wall Street Journal do read these things. They don't really always admit to it, but they do. But also the business press and the industry press. If it's technology, it's very hard to get a fair hearing or a fair coverage from technology press if it's a patent case brought by a plaintiff. They don't like that, for a variety of reasons. So they tend to be very sympathetic to defendants and tech coverage in the media. But does that answer your question?
The question is then, what is the value? Let's say you get positive coverage in the Wall Street Journal about your case. Maybe that's the Holy Grail or whatever. From your perspective,
does it put pressure on to settle? It may. There have been instances where if a company is public and there is a major lawsuit, when the suits looked like they had meaning, like 10 or 15 years ago, when they looked like they had meaning, and a small or private company, or could be an inventor, independent, filed. And it was let's say they, looked like it could be a $500 million case. Would that move the needle in terms of stock price? Yes, it could. Not always one-to-one relationship with the announcement, but at some point it would move the needle. And would that put pressure on the defendant to settle? It could, but it was never the specific strategy that I dealt with.
What is the strategy? Who do you want to see this media coverage?
Well, I want to see the IP community, so it's clear, because even within the IP community, for example, NPEs are not well understood. There's a spectrum of NPEs, and not to throw, I've worked with clients who don't want to throw other NPEs under the bus. However, they're very successful, have hundreds of millions in licensing deals, and they're all inventor-owned patents. So why are they being called troll? Because they don't practice. That's a big issue for a lot of NPEs. Defendants have, other agenda.
Going back to that specific litigation that you have going on, I mean, what is the value? Let's say all these patent attorneys think what I'm doing is great, but what is the value to that specific litigation that you have going on?
Well, the values to the litigation, yes, but also there's value. There's value to the assets. That if it's well understood, the case is well understood, and the assets are well understood, then it's good for it. Potentially good for shareholder value, stakeholder value. It's potentially good for the court, but not specifically aimed at influencing, the final decision. It may, does it?
Okay.
It could, and it probably does, but we never thought that specifically. Just want people to be aware of the facts, I think, is really the key.
That's interesting. So it's not really about that one lawsuit against this one defendant. It's really about a broader strategy where you're going to be trying to kind of enforce your portfolio, or let's say patent owner X, he's somebody who's not just filing frivolous lawsuits. He has a story to tell. He has patents. So next time he files a patent
That's right.
lawsuit, well, taking seriously.
And maybe someone will take a license because they know there's value here. It's not just some, another troll filing another suit, but there's actually good patents because they've been talked about in the press. Their claims are strong. There's a good case here. Maybe it pays to take a license. I had a client during the worst of licensing times, I guess during the pandemic. They were still closing licensing deals in the seven figures, much lower than they had in the past, but they were still doing that. So how do you communicate that? You can't take out an ad in the New York Times and say, we're still closing licensing deals. We have great patents. That's how good they are. But subtly, we can remind people within the industry, within the business community, that these are exceptional, and this is why. And here are experts who have opined on that. And that's part of the methodology that we employ.
Still want to talk a little bit about that individual litigation case, because you do see that kind of strategy deployed, I guess, in other areas of law. For example, AT&T and DOJ, when DOJ was suing AT&T was spending tens of millions of dollars on a PR campaign to kind of explain why they were in the right. And obviously, maybe those kind of, it's unrealistic to do for a patent case where you think, you're going to somehow influence a jury pool or a federal district judge.
You're not. But I think while the case is front and center or if not front and center, at least in the media, want to make sure they get it right. And journalists often don't get it right. We just did something with Gene Quinn from IP Watchdog and Sue Decker, who worked with Bloomberg News for 23 years. They're as experienced IP journalists as anyone in the world. And there are a lot of frustrations, and the media often does not get it right. Sometimes it has to do with ignorance, a lack of information, but often it has to do with agenda. Often it does. And I don't think readers are attuned to that.
So I've seen some examples in the patent world, and I want to get your views about them, because there's sometimes there is a very limited audience that's going to make a decision about your case, right? Sometimes, it's going to be the 12 federal circuit, the federal circuit judges. Sometimes, it's going to be the 9 Supreme Court justices. And sometimes, these days it's going to be the one USPTO director who's going to do that director review. Maybe let's start with that example now. It's a very interesting situation where, the PTAB, which is a tribunal at the USPTO, can kind of invalidate patents. They have a lot of power, but now the USPTO director can kind of overrule them. And it's been kind of a new process, but what I've seen is, at least to some degree, it's the cases that get a lot of media attention that the USPTO director ends up considering for review. Is there a realistic strategy to say, my case is going to be going under, there's going to be a PTAB trial. I want the PTAB judges to know, I'm the good guy. I'm being blah, blah, blah. And I want the PTO director to be aware of that case. Is that a realistic PR strategy?
That is a realistic PR strategy. I think if they see quality coming out of your organization with regard to IP over a period of time, licensing deals that are struck, not contentiously, but because people want to take a license. I mean, look at a company like Qualcomm, specifically. I mean, they have a stellar licensing reputation. They still run into disputes from time to time, but that not everybody in the world knows about Qualcomm. In the IP world, perhaps. Another example along these lines is you take someone like Micron Technology, which is building a huge fab plant in New York. That's besides the point, but they're almost unknown. The brand doesn't exist in the business world. I mean, maybe today it does a little bit more than 5 years ago, but very, very little. Yet they have some of the most stellar semiconductor patents and technology in the world. To me, as a marketing person, that's a mistake because you're leaving money on the table. You have a brand already. You're just not building it out and extending it, which it can help not only for stakeholders and shareholders, but in court as well, if you have a reputation for quality.
Before the oil states Supreme Court decision, before the arguments, I saw in the Wall Street Journal, and you mentioned the full-page ads. There's a full-page ad from some, I guess, quote-unquote, think tank about why patents are bad. I mean, I looked into some of the facts they presented. I didn't think they were accurate. They actually discussed this really bad patent that was actually invalidated. And I'm like, the only reason they're putting it there is they're hoping that a Supreme Court justice is reading the Wall Street Journal that morning and sees that ad and is influenced by that ad. Do you think that's an effective strategy? Can you really convince?
No, I don't think that's the only reason. I don't know who did that ad, but my guess is the motivation is, it's multi-level. Yes, if a judge saw that, PTAB judge or administrative judge saw, that would be useful. It might influence them. But I think in general for shareholders, you think of stakeholders, IP stakeholders. It's not just, the owners of the IP. It's shareholders, it's employees, it's people in the community. There's a whole host of folks that are confused about IP. We actually just did with US IP Alliance, we did a big survey, 1,000 respondents on what Americans know about intellectual property. And they know something, but they're pretty confused. They really don't get much education. And, the question would be, well, why do they need to know? I mean, it used to be patent attorneys knew, but regular lawyers didn't know anything. And they didn't care. Let the patent attorneys, they're engineers, they'll take care of it. But that changed dramatically in the last 15 years, as you know. And I think it's changing for people as well. People need to know something. They don't need to read claims, but they need to know how these patents are being used, why they're important, why the U.S. needs strong patent protections to offset, say, the Chinese. That's not very clear and not very well articulated.
Tell me if I'm wrong, but my main takeaway is kind of a little bit too cynical to think about PR as kind of a strategy for influencing the individual decision makers. It's really a broader way to tell your story, kind of a longer-term strategy, not an immediate.
That's right. I mean, but on an immediate level, Eli, I would say, if someone files a case against you, a major case, it looks like it's going to be a big case, and or you're a plaintiff, you should be prepared with how that's going to play out in the media, because it will on some level. Maybe just the IP media, maybe the tech media, maybe business and investor media all together. But you have to think that through, because it will play out and you will be positioned in the media, whether you like it or not. And given that, you owe it to shareholders, really, and to your company to make clear your position if you feel it's a valid one. You don't have to wave the flag, but you have to. And don't forget, the other guys too are going to be positioning themselves. Well, you have to be mindful of that.
You mentioned, I think it's because of the world that you come from. You mentioned shareholder value a lot, which I guess is the stock price. But even kind of less, maybe more directly, a big role of a in-house counsel or a chief IP counsel within a company is to tell the story of why you need patents, right? Because, as you say, a lot of people, even within a company, might not be aware of that. And leadership changes, right? You might have a CEO who kind of is very attached to patents and knows the value of patents. And then you might new CEO who, let's say, comes from let's say a marketing background, but not an IP background. And you need to kind of highlight the value of patents. I mean, what advice would you give to in-house counsel about educating within your organization and outside of your organization about why IP is important for your company and the value of IP?
Well, of course, it differs from company to company. Patents may be more important in one company than another, and trade secrets may be more important for still another. Marshall Phelps, who is the co-founder of the Center for Intellectual Property Understanding, which listeners should realize is a nonprofit. That's an independent nonprofit, 501c3. It's not my day job. But Marshall said for Lou Gerstner, who came in as CEO, who knew nothing about IP and not much about technology, really, he put little flags in IBM's laptop at the time, the ThinkPad, and those were all the areas that they didn't have patents. So they had a license in. And they licensed in because they had patents to cross-license. They had leverage to do that. They didn't have to pay for that. They were able to put out the ThinkPad at a profitable price because of that. So it's kind of a dramatic way of showing what you don't have and what you need to bargain for what you don't have. Otherwise, you're going to have to pay for it.
For some companies, they have this big portfolio of patents, and if they're not involved in active litigation, it just seems like a cost center, right?
Right.
Where they're paying a lot of money to get these patents, then they're paying all these maintenance fees to maintain these patents. And I guess there must be to some executives out there occurs the thought, well, what if we just stop doing it and save all this money?
Right. I had a client, a Fortune 100 client, who was diminishing their number of patents. They had a lower number of patent grants received from the U.S. Significantly and over a number of years. And so how were they going to show they're no less innovative and no less profitable with regard to innovation, despite the fact their number of patents have gone down? That was a good question that we worked on with them on that for a couple of years.
And, it kind of brings me to a story that I heard when I started practicing is that
a story about me?
No,
Okay.
no. Japanese companies used to believe that the more patents they get, it was an indicator of innovation.
Paper patents, they call them.
And in some ways, it's a kind of a cheap. It is an indicator of innovation, right? I mean, you're not going to be obtaining patents if you're not innovating.
Quantity isn't everything. It means it means something, but it's not everything. But I think it was HP years ago, Steve Fox has said, he was the chief IP exec there. He said, they just expect it to go up 7 or 8%, the number of patents they get. They don't care. Just make sure they go up. And that's so wrong, and it really gives IP and patents a bad name. It's not about weight, it's not about quantity.
Yeah, it's about the meaning behind them. And I think that's why you do need that parallel strategy about how your technology ties into what you're getting patents for.
Exactly.
I was thinking about PR marketing, and probably the two words that come up most often on my podcast are patent troll. And it often comes up most often when I tell people what I do. When they find out about I'm a patent attorney, the first words that come out of their mouth is patent troll. When I live in DC, so once in a while I meet somebody from Capitol Hill, and I tell them I'm a patent attorney. Once again, the only thing they know is patent troll. Somebody who spent his life, in the marketing and the PR field, why has that kind of grabbed the imagination of the entire world?
Well, it's an image and a term that resonates. And in addition, it's been promoted, quietly by powers that be that see, the perpetuation of that notion as being useful to them. They can remain nameless, but I think we have an idea. The tech scenario, tech would like to belittle patents. Some tech companies, not all, because they're a threat to them. So patent trolls wield patents, so patents are bad. It's a scenario that benefits them indirectly. But just when you think, this is interesting to me, just when you think they've gone away, like the patent troll meme is kind of fading, you see in obscure places comedy, Adam Carolla talking about, John Oliver talking about patent trolls. How do these guys even know about patent trolls? But they're talking about them front and center, of course, belittling patent trolls. I don't think it's totally an accident. I really don't. I don't. I'm not an investigative journalist. It's not my job. But it's very odd that the meme has really not gone away, and there's not much effort done to dispel it, even on big tech side.
there's obviously the imagery, right? It's funny because I am in the patent world. Whenever I think of a troll, I think of a patent troll.
Gene has said, efficient infringement just doesn't cut it. It's just, it's like kissing your sister. What? Efficient infringement. But serial infringer, that has a connotation. Serial infringer. Yeah, we don't play that game to promote terms like that, but we see the value of it. And, an interesting, Colleen Chien at Santa Clara, a professor, she wrote about, this was 15 or more years ago, about patent assertion entities, licensing companies. So by nature, she's suggesting that they are assertion entities. They're not. Patent licensing companies don't start out being assertion entities. They become assertion entities, and sometimes they have to. Often they have to. But they would rather license. So to kind of group all NPEs as assertion entities, that's another kind of nasty, and then catch on the meme the way the patent trolls did. But it's a term that never should have existed. So she quoted herself a couple of times using patent assertion entity, and then it became, in use.
No, and that is actually an interesting comment about how, there's room to be very effective in the IP media space, because most patent attorneys, they don't want to get out there and kind of express opinions and whatever, but so it leaves room for powerful actors or not, even people who are willing to talk to kind of make an outsized impact. You're shaking your head in agreement. So I guess, do you have any thoughts about how to be effective?
First and foremost, I have no technical, legal, or business degrees.
Yeah.
But I somehow, when people, this was years ago, I was dealing with someone, they said, so where did you practice? Well, they were surprised I wasn't a lawyer. And I guess I take it as a compliment. Maybe I shouldn't. But the point is, you can learn about these things. It's not that difficult. I remember, this was many years ago, I was working with a Hollywood investment banker, sort of a mid-size, and he bought some editing companies when digital was sort of beginning to take off. And I said, he had a degree in languages from Yale, I think. I said, how do you know about all this stuff? He said, well, I buy something, I have to understand what I'm buying, and he was a bright guy. He was more of very much a liberal arts kind of guy, but he learned what he needed to learn to do the deal. And that impressed me and inspired me to kind of, you could learn this stuff,
Another interesting way, I think, in the public imagination that you see, at least I think, and maybe there's probably disagreement about that, there's at least more appreciation for other IP rights than there is for patents, especially for trademarks. I think people know, that's a business that they started. Nobody has a right to use that same name to kind of rip them off. But even for copyrights, I see, on Capitol Hill, in the Supreme Court, for copyrights, you get 75 years or something like that. Do you need that kind of incentive for copyrights compared to the investments that you need for patents? I mean, you obviously have a Center for Understanding of Intellectual Property. You deal with all kinds of IP rights. Do you have any thoughts about why?
Yes. Yeah, that's a very good point. I've always said to my board and others that the trademark and copyright are kind of the tail that wags the IP dog, if you will, because people can relate to plagiarism. Oh, that's bad. Plagiarize this, and fakes and counterfeits. That's bad stuff. Even though I buy them, it doesn't matter that it's bad. But the patent concept, rich companies kind of, battling each other, or even an inventor who had enough money to hire a law firm and file patents. For maybe the average person, it's not that fascinating or seemingly relevant what it is. But I think through the kind of the back door, if you will, of trade secrets, trademarks, trade secrets is a difficult area, because that also seems like it's the province of big companies, not my problem. But fakes, counterfeits, and plagiarism. So I'm told an epidemic of plagiarism in schools now. People don't know how to write a paper because not that they can't write, but everything is there for them. Why should they Right.
Yeah.
Isn't that what people do? They just cut and paste. And the cut and paste world that we're living in, digital world, that covers the patent perspective as well. It seems like everything's cut and paste. No?
Yeah. And another narrative, I guess, with patents, and we saw this during I think the COVID pandemic, is that somehow patents are an impediment. They're an impediment to innovation, which
Right.
is, odd if you're in the patent field. Literally, I guess in some ways they are an impediment to immediately lower drug prices. I think there's been a pretty successful narrative built around that instead of patents being a positive thing where without them, this innovation wouldn't be available in the first place, they're actually an impediment for that.
Well, in Brussels during the COVID vaccine buildup, there was even a billboard that said "patents kill." That's how it was being portrayed. There's a lot of.
That's actually on bus stops in DC as well. So,
Oh, really?
yeah.
Really? And it's very sad because they so missed the boat. If with all due respect to NIH and Pasteur and Max Planck and all these great national health institutes, if they could come up with something, say a COVID vaccine, they would have. But they couldn't. They needed more money. They needed more distribution expertise. Needed a host of skills and resources that Pfizer has or has still. But anyway. It's important. Yeah, I think the COVID vaccine waiver is something that's it's still going to be around, even though the notion that not the pot. It's like the glass half empty and glass half full. Not that Pfizer and Moderna came up and others with a life-saving invention within 9 months that saved tens of millions of lives and mitigated other.
Yeah.
That they're holding something back, and they did such a great job, but you're going to take it away from them. And then and in the future, that's not going to matter because we need to deal with this now.
And obviously, I'm a bit biased as somebody who makes money off patents, but I would think, the whole COVID, the miracle of these vaccines would have been an opportunity for everybody to say, wow, how were these companies able to come up with these vaccines in this miraculously quick amount of time and all that. Before we finish, I really want to kind of talk about our mutual passion, which I think is podcasting. And tell me a little bit, I guess, what you've been involved in all kinds of media. Like I said, you helped found IP publications. You've written a lot of IP columns. You've written books. But what made you want to do a podcast, and what have you learned from doing it?
It seemed like a natural extension of what I am doing. It's not, I always tell people it's not NPR. We're not going to get to, millions of listeners, but we're going to get to, a fair number. We have thousands of uploads. I think there's an audience out there. I think IP needs to be discussed a little more broadly, like we're doing here now. And I think there are folks who are motivated to listen to a podcast who won't listen to other things. So I think the time has come. And also, I think the conversations like this one bring out something that, say, a written piece does not. Challenging me the way you do on things is a healthy exercise, for listeners, and for us as well. So I think it's it's interesting. It's a lot of work, a lot more work than I thought. Research, preparation, some editing, and production, but it's worth it.
Is there anything that I guess you kind of discovered about IP or made you think differently from talking to the different guests?
Yes, I think it's that some guests, and I'd like to believe those are the ones we have on. They can be a great economist and academic and scholar, but they can also speak about IP in ways that investors and students and educators can understand, consumers even. It's not an absolute necessity, but it's a useful skill to have. And I think more and more people realize that. we're living in such a fast environment. It's like, Twitter and Facebook are kind of off to the side. Now everything is LinkedIn today. Tomorrow, I don't know, TikTok as well. Things move awfully fast. For our IPbasics.org platform, and that's sort of a portal, if you will, to get people, and it's for IP professionals as well, because very often, the thing we do at these events that we have,
and that's a project of Center for Intellectual Property.
Correct. Yeah, the IP Awareness Summit, we've done 5 of them. We'll have a 6th one in the spring. But what's interesting is we have about half the people there are IP-related people, maybe more. But they agree, no matter who they are or where they come from, pharma, tech, big tech, small tech, independent vendor, IP is misunderstood, it's undervalued, and it's often abused. Everybody agrees with that.
Yeah.
But no one agrees on how to discuss that or why it should be discussed with the world. And that's kind of scary. So IP professionals need to understand something about IP basics as well, how to discuss them and put them in context and not just, hide behind the very legal aspects of it.
That's interesting. It's almost a statement against interest to say that IP professionals need to learn how to communicate about IP on their own.
That's
they
right.
Can't just pass it off to
that's right.
communications professional.
They have a responsibility. I think, and I'm not, I'm not a lawyer, but I think they have a responsibility to help explain how IP is used, where it comes in, who it benefits, not specifically, but in general terms.
And you mentioned the recent interview you did with Sue Decker, formerly of Bloomberg, and Gene Quinn. And, a topic that you discussed is outside the IP community, people find they're intimidated sometimes about patents. They just gloss over. They're not interested in following it. And, a lot of these, there's a lot of organizations. There's, obviously IP Watchdog and IAM that you helped found, which everybody in the IP community reads and loves their content and so forth. They listen to our podcasts. But how do you communicate beyond? And you mentioned, you need to learn how to do that. But what is an effective way to do that? Can you give us some strategies?
We think something like ipbasics.org is something that's important. And if you look at that homepage, it's very visual and it's very kind of product driven. We show Legos, we show an iPhone or a smartphone. I'm trying to remember some of the other things. We show something that's generic, amoxicillin, I think. How did it get to be generic and how did it get there? And kind of backing into the discussion of IP that way, I think is useful. People seem to like it, both professionals and non-professionals. And I think young people, students are getting a lot smarter about IP. Certainly athletes are. And students are as well. There's an awareness of copyright. They're kind of not sure what it is or where it fits in, but I think there's a greater awareness than in the past. Some people are saying that, someone in Colorado I dealt with, a professor, he said they want to teach IP in the civics curriculum in Colorado as a state requirement. I like that.
No, that's a good idea.
Yeah.
Well, let's end with that. Maybe IP and patents can become part of high school civics classes as well.
Right.
And maybe that's really
along with George Washington and Thomas Jefferson, right?
Exactly. And one of your books, I obviously Thomas Jefferson is known. He was for his role. I think he was the first examiner, right? Yeah.
But he didn't really love patents. I understand Madison had to convince him that patents would work.
But you even quoted, I was going to say, Abraham Lincoln, who had an appreciation for innovation. So I think it's something that is definitely part of our history.
To me, Madison was really important because he wasn't an inventor like Franklin and Jefferson, who were inventors. They weren't in love with patents. They had to convince them. Matter of fact, Franklin gave away, I think, the Franklin stove rights, or he kind of made them, he was open source, I guess.
Yeah.
But Madison understood the dynamics, and I think, and Hamilton too, understood the dynamics of how the IP could work for a young country.
Thank you, Bruce. Thank you for joining Clause 8. It's been really fun to talk with you. hope we get to continue this conversation again in real life sometime.
Yes, thank you for inviting me. It's been fun.
Thank you for listening to Clause 8. If you enjoyed this episode, please share it with others and leave a 5-star rating. I'd also like to thank my firm, Harity & Harity LLP, for their generous support. Clause 8 is produced by Great Feeling Studios and Brick Brewer. For more information, visit voiceofip.com. Thanks for listening.